Imagine the people who decide your constitutional rights are too scared to say out loud who won a presidential election. That's not a hypothetical. That's what just happened in the United States Senate. 4 people nominated to be federal judges for life sat in front of Congress and refused to confirm basic, documented facts because the administration that put them there was watching. And Senator Whitehouse didn't let that slide. What you're about to see is what judicial capture looks like, not in theory, not in a textbook, live on camera under oath. And the question it leaves behind should keep every American up at night.
Just to finish Senator Blumenthal's point, I hope you realize how ridiculous the 4 of you look. Spouting these preposterous, canned answers in a forum in which A, you're supposed to tell the truth, and B, you're supposed to demonstrate the judicial capacity to make independent, factual decisions in hard cases. If you can't even sit here and say that Joe Biden won that election or that the Capitol was attacked, what's left? What's left if a hard case comes your way as a judge, and let's say the Trump administration is bearing down on that? Why would we ever believe that you would give the litigants a fair hearing and a fair decision if the executive branch was leaning in on you when we can't get a reasonable answer out of any of you with the executive branch leaning in on you to give these ridiculous answers today? I'm really sorry to have to go through this and that you have to go through this. But it would be nice if you could tell your executive branch handlers, for instance, Ms. Clark, I'm supported by Lindsey Graham. He's a friend of President Trump. He's the second senior person on the Republican side in the Judiciary Committee. He's likely to be the next Judiciary Committee chair. I think I'll be okay. I don't need to make myself ridiculous at your direction. It'd be great if you could have said that. It would be great if your answers were simple and honest here today. It's really disappointing. Let me ask a different question, a legal question. A judge, you want to be judges. A judge gets a threat to the judge's life or to the judge's family. Can you imagine a scenario in which liability may attach to individuals beyond the utterer of that threat? Ms. Clark?
Senator, as a prosecutor, there are instances where there's some responsibility that is assigned to someone who is not the utterer of a threat to an individual. And so to answer your question, yes, I can imagine.
Do you agree?
Yes, Senator, and if confirmed to the bench, I would follow all Supreme Court precedent and Ninth Circuit precedent.
Mr. Rick, you agree?
Yes, Senator, I would agree with that.
I don't know that I care what you think, Ms. Westerkamp, because you're going to international trade and you're probably not going to see much of this, but do you agree?
Yes, Senator.
Yeah, and those doctrines that would provide the legal basis for investigation in those scenarios would include doctrines like, name one, Ms. Clark.
Senator, doctrines that are, if someone is essentially carrying out
solicitation, would that be one? Solicitation of a threat?
Yes.
Or a conspiracy out of which the threat emerged, would that be another one?
Yes.
Yes. How about, and it's the product of an enterprise under the racketeering statutes. Would that also be another way that liability could extend beyond the utterer?
That is correct, Senator.
Can you think of any others, Ms. Lane, where liability extends beyond the utterer of the threat? What are some of the legal theories that would support that kind of investigation and prosecution?
Senator, the doctrines you mentioned, I would agree with, and I would just look always to the federal law and federal statutes guiding that.
Mr. Rickey?
Senator, I would agree with that. I think you covered the major ones, conspiracy, RICO. There may be other avenues of potential legal liability, but I think you covered the three big ones in that scenario.
Ms. Westerkamp, you agree?
Senator, I'm not aware if there are any more with my practice before the Court of International Trade and Court of Federal Claims that doesn't touch on criminal law.
So here's why I asked you these questions. I asked you these questions because right now federal judges are under the worst shadow of physical threat in my lifetime and perhaps in the history of this country. And in responding to those threats, we have the United States Marshals Service, which reports to the Department of Justice. And I have now over a dozen times asked the Marshals Service, will you investigate behind the utterer of a threat if the evidence justifies it? That's a super easy question. The answer is, yeah, of course we will. They won't answer that. They won't answer that. And I point this out because judges across the country need to pay attention to the fact that the Marshals Service won't confirm that it will investigate behind the utterer of a threat if the evidence supports that. And why would that be the case? That would be the case because when you get behind the utterer of a lot of these threats, you run into right-wing conspiracies. And this MAGA Department of Justice would rather not go there. And so they leave judges exposed with investigations in which they aren't doing investigative 101 work that you've all identified as plausible legal theories. And we need to fix that. We need to fix that.
Let me start with something that might feel obvious, but actually isn't. What you just watched wasn't a senator losing his temper. It was a stress test, and every single nominee failed it in the same direction. Whitehouse wasn't asking those 4 nominees trick questions or setting a political trap. He was asking the simplest version of a much harder question. Can you tell the truth in public when the administration that appointed you would prefer you didn't? And 4 times, the answer was no. Before we go further, I want to explain why that failure is more alarming than it looks, because the surface of it is easy to dismiss. You might think, okay, they gave cautious answers, politicians do that, so what? Here's so what. When a person is nominated to a federal judgeship, they are not applying for a position they can be fired from. Article 3 of the Constitution gives federal judges lifetime appointments and salary protections specifically so that no president, no party, and no administration can punish them for ruling the wrong way. The entire architecture of the federal judiciary rests on one foundational assumption, that once confirmed, a judge's loyalty belongs to the law, not to whoever put them there. So when Whitehouse asked whether Joe Biden won the 2020 election, a fact certified by every relevant institution in the country, he wasn't being provocative. He was asking, do you understand that your job requires you to follow facts even when power tells you not to? And they blinked. Now let's be precise here, because precision is what separates analysis from noise. The nominees didn't lie. What they did was more revealing than lying. They performed uncertainty about something that has no uncertainty in it. They used procedural language and judicial caution as a shield against a question that required neither procedure nor caution, just honesty. And that kind of coached, careful, strategic evasion tells you something important about what comes next. These nominees have already been shaped, before they've been confirmed, before they've heard a single case, by what this administration expects from them. That is what judicial capture looks like in its earliest stage. Not a judge ruling for the president on live television. Something quieter and more permanent than that. It's the preemptive alignment that happens in a confirmation hearing, in the silence between a question and a non-answer. A nominee who has already learned which answers are safe. I want to pause here because the hearing took a turn that most coverage completely missed. Midway through, Whitehouse shifted gears and asked a technical legal question. If a federal judge receives a death threat, can liability extend beyond the person who made the threat to the people behind them, The networks, the organizers. One by one, the nominees said yes. Under conspiracy law, yes. Under solicitation doctrine, yes. Under the RICO statutes, yes. The framework is clear. You can go after the people who built the environment in which a threat emerged, not just the person who sent the message. Now here's why that question mattered, and why Whitehouse's next words landed like a hammer. Right now, federal judges across this country are living under the worst shadow of physical threat in his lifetime. And the United States Marshals Service, the agency that protects them, reporting directly to the Department of Justice, has been asked over a dozen times whether it will investigate behind the direct utterer of those threats. More than a dozen times. The answer, every single time, silence. Sit with that for a second. The nominees just confirmed the legal tools exist to do exactly that work. Conspiracy, solicitation, RICO. There is no legal obstacle here. There is no procedural barrier. So why won't the Marshals Service confirm it will use them? Whitehouse's explanation, and I think he's right, is that when you follow those threats back through the network, you don't end up somewhere politically neutral. You run into right-wing extremist infrastructure. And this Justice Department has made a quiet calculation. It would rather leave federal judges exposed than go there. I want to be careful about what I'm claiming and what I'm not. What Whitehouse is describing is a pattern of deliberate non-response, not a proven written order to stand down. But here's the thing about law enforcement. The absence of an investigation is itself a decision. When the agency responsible for protecting federal judges won't confirm it will follow the evidence wherever it leads, that is a policy, spoken out loud or not. And think about what that policy does to a judge sitting on a sensitive case right now. Maybe it involves executive power. Maybe it involves a politically connected defendant. You know, as documented fact, not paranoia, that threats have been made against judges like you. And you know the agency assigned to protect you won't commit to going after whoever is behind those threats. What does that do to your willingness to rule against the administration? What does that do to your independence, not through any explicit pressure, but through the steady, quiet withdrawal of protection? This is a chilling effect on the judiciary, not a dramatic phone call from the White House, not an order anyone has to put in writing. Just the slow signal that certain networks won't be investigated, certain judges who rule the wrong way may find themselves more exposed, and that nobody at the top of the Justice Department is going to stop that from happening. That signal doesn't need to be spoken to be received. Whitehouse connected these two things, the nominees who couldn't answer a factual question, and the Marshals Service that won't do its full job, because they belong in the same frame. They are both symptoms of the same condition. An executive branch systematically probing how much pressure the judiciary can absorb before it bends, how much silence it can produce, how much protection it can withdraw before judges start ruling with one eye on the law and the other on their own safety. The American judiciary has survived a lot: corruption, politicization, pressure from powerful administrations. But it cannot survive the collapse of the one belief that drives it, that the people inside it are making independent decisions. Once that belief erodes, courts don't stop operating, they just stop meaning anything. And we get there not through a single dramatic rupture, but through coached non-answers, withheld confirmations, and quiet withdrawals of protection, each one small enough to dismiss on its own. Here's what I want you to hold on to after this. Whitehouse went into that hearing with the easiest questions he could construct. Not constitutional puzzles, not legal traps. Did Biden win? Was the Capitol attacked? And the people about to be handed lifetime power over your rights couldn't answer honestly. That's the preview. And if we normalize the preview, we won't recognize what comes next. Share this with someone who still thinks confirmation hearings are procedural noise, because they are the place where the future of the federal judiciary is decided, one evasive answer at a time. Subscribe for deeper breakdowns, because this is exactly the kind of moment that vanishes in the daily news cycle, and it's too important to let disappear.